Welcome, everybody. I'm Louis Lowe, a corporate law partner at Foley & Lardner in Silicon Valley, here with my good friend, Pat Doherty, to tell this great audience of entrepreneurs and hopefully a few lawyers in there about the latest and greatest on the regulation of cryptocurrencies in the United States. Pat, please introduce yourself and say a few words.
I'm coming to you from Chicago, where I live and work, and I'm really pleased to be part of this program today. I spent 40 years and counting as a securities lawyer in the United States, and for the last several years have been deeply involved in the emergence of crypto assets and other digital assets. So I'd like to share the landscape of U.S. regulation with the audience, Louis.
Thank you, Pat. And just a word about the agenda here. We're going to first give you a broad overview of money and digital assets as we see them here from our vantage point. A quick overlay of the panoply of U.S. regulations. We're going to provide just a little background on the fundamentals of securities law regulation. We'll do a deeper dive into digital assets, and we'll leave you with some points to ponder, all in 30 minutes. I'm sure that is probably a tall order. We're going to go through this very quickly, and we invite members of the audience to reach out to Pat or myself with follow-up questions over email. And I wanted to also thank my good friend Chan Woo Sung and the Delight Law Group in Seoul for inviting us today. Pat?
Great. So let's begin with the money tree. This is created by the Bank of International Settlements, and they constantly refine it as new kinds of money are invented. Notice, in analyzing the different kinds of money, the features that money can have. It can be digital or not. It can be peer-to-peer or not. It can be widely accessible or not. And it can be central bank issued or not. That may be one of the more important features. Notice these features overlap. So I'll give you a few examples. In the center, above, I'll call it the above center portion, where we have digital money that is central bank issued and is not widely available and is not peer-to-peer. What could that be? Those are central bank reserves and settlement accounts. Beneath that, we have widely available central bank issued money that is peer-to-peer and is also digital. What is that? Well, that doesn't exist quite yet, but that is where FedCoin lies, which is to say currency issued in digital form by the United States Federal Reserve. Although the US hasn't gone there yet, we're exploring it. Other sovereigns are issuing, engaging in the same exploration. China, for example, is developing this kind of money. To the left of it, you have central bank issued digital currency that is widely accessible. What is that? Well, that doesn't exist yet either, but we're working on it. At the very bottom, we have widely accessible money that is peer-to-peer, but it's not digital, and it's outside the central banking system. Well, what could that be? The answer is precious metals, such as gold, silver, maybe diamonds. Those are commodities, but they are money, nevertheless. They've been money for millennia. I could go on and on. How about central bank issued and peer-to-peer? So that's up here in the, I'll call it the northeast quadrant here. Not digital, but issued by a central bank and peer-to-peer.
What's a digital asset in the securities laws, and how's that different under the tax laws in the United States?
Well, I want to talk about that. A digital asset in the securities laws is probably a coin or a token or a virtual currency. You see those words highlighted in the definition here that we've been given by the Securities and Exchange Commission. How does it differ from its use in the tax code? Not much, because the tax laws treat virtual currencies as property.
Exactly, and any trading you do is taxable if you have any gain. Security or not, commodity or not, it's property, and you make a profit and it's gain.
Spot on, correct. A profit or a loss, and if you don't report it, then you're at serious risk of being prosecuted by the U.S. government. They're starting to track that. There are questions on tax returns that you have to answer if you buy and sell. And even if you don't buy and sell, you simply buy virtual currency, you have to say so on your tax returns. So they are
I
tracking
think there was a
it.
big crackdown in securities regulation of tokens in the 2019 timeframe. And then I feel like the last year we've seen a crackdown in pursuing people for failure to report taxable gains in digital property. But I think this is a great slide on what is the definition of a digital asset for purposes of the securities laws.
Yes.
And we in the United States have two principal regulators. One is we have the Securities and Exchange Commission, which is a federal overlay that applies in all 50 states to the extent that there's a transaction that occurs in interstate commerce. And then we have a self-regulatory organization called the Financial Industry Regulatory Authority, or FINRA. And the FINRA is the self-regulatory organization that all participants in the securities markets must be a member of. And to be a member, you must register with the SEC. So those are the two principal bodies that govern our securities markets in the United States. And this slide gives some definitions, and we will share a copy of these slides with Chan and the folks at Delight for you to look at after the meeting.
Well, very briefly, this isn't law. This is just how I view the universe of digital assets. Coins have general use, but in fact aren't used much yet. That's changing quickly. But we're talking about Bitcoin, Ether, Litecoin, Ripple, others of that sort. When I say they aren't used, I mean they're not used to purchase goods and services much. Not yet, mainly because of the volatility. But that will change, but those are coins in my view. Tokens are something else. Tokens, they don't have a general use, they have a specific use. And they are in fact used as intended. These are sometimes called utility tokens, and thousands of them have been created. You can think of them as being, sort of like movie tickets, for example, or subway tokens. Those are tokens. Now put it in digital format and in smart contracts coded on a blockchain, and you have a digital token, mainly used for consumption, and we'll talk more about that. The third category is stable coins, which are a proxy for fiat currency. Since I'm in the U.S. and the U.S. dollar is so important here, the ones I work with most are proxies for the U.S. dollar, such as Tether and GUSD, and there are others. These mainly serve as a bridge from crypto to fiat and back, in my view of the world, and as they're used in trading markets and among investors.
But one question I get frequently is, what is the difference between a utility token and a security? And can a utility token be a security, and can a security be a utility token, or are they two things that never shall the twains meet?
It depends on who you ask. If you're asking the SEC, and it's important to know what they think about this, almost all utility tokens are securities. That's not what the folks who created utility tokens had in mind. What they had in mind was something that's not a security. But unfortunately, the SEC has taken a very aggressive view and a very restrictive view in how it interprets the definition of a security. And most utility tokens, by their definition, are securities.
Are tokens commodities or derivatives? And what's that, Pat? And why do we care?
Well, if they are commodities or derivatives, then they're not regulated by the SEC. You're either a commodity or a derivative on the one hand, or you're a security on the other. And you want to be regulated as a commodity or a derivative in this business because that's a very light touch, which the CFTC has. Securities regulation is rather more extreme. It's highly intrusive, and it's virtually impossible to have a digital asset securities without spending an awful lot of money on compliance. But commodities and derivatives, again, a light regulatory touch. So that's where you'd like to be classified if you could.
So we talked about property, Pat, and how the IRS governs tokens as property and taxes us. We haven't talked about money. If a token is not a security and it's not a commodity, it's not a derivative, and it's not a utility, it's just a method by which a metric of value is exchanged, then that's money. How's that regulated in the United States, and what is the FinCEN?
Well, the Treasury Department regulates money. And the Treasury FinCEN is the Financial Crimes Enforcement Network. So that's all about money laundering, basically. So we have laws, as other nations do, regarding licit and illicit uses of money, state-sponsored terrorism, narco trafficking, this sort of thing are at the heart of the concerns regarding money laundering. And because of that, the US Treasury requires money transmitters to register as money transmitters and to adopt and maintain policies and procedures, compliance policies and procedures to avoid money laundering by their customers, by people on either end of the transaction. And this applies not only to US dollars, but to other kinds of money. Specifically, it does apply to crypto assets. So it's just one more way to be regulated in the United States.
Some great references here on the bottom, and obviously we're going to focus a lot on securities today because we are securities lawyers, and that is the most important metric of regulation in the United States. Although, as I remind people, the Treasury and the FinCEN, if you succeed in avoiding SEC regulation, you really need to be registering with the Treasury or FinCEN as a money transmitter, and oftentimes in states as well as in cities. The city of New York has a regulation that requires the registration with their authorities for transmitting digital money. What are some other important laws that we should be thinking about when we describe regulation of cryptocurrencies in the United States, Pat?
Well, you just mentioned the most important thing, which is the federal system of law in the United States. We have federal laws, but we also have 50 states, the District of Columbia, we have Puerto Rico and other territories. They all have laws covering securities, crypto assets. Many have crypto asset laws. The New York Bit License Law is especially strict. The Office of Comptroller of the Currency engages in banking regulation in this area, as does the Treasury, which we've already mentioned. If you do innovation in this field, patent and trademark law is certainly implicated. There are consumer protection laws. And of course, there are non-US laws, rules, and regulations. I'm going to mention the emerging importance of the state of Wyoming, which will strike some as odd because it is not a major commercial center, but Wyoming is sort of the Delaware of crypto assets, in the sense that it is adopting a code of laws that are really geared toward crypto asset development in a very facilitative way. That doesn't mean that the SEC will defer to Wyoming, however. The SEC has made it clear on several occasions that insofar as the federal law is concerned, they will make the rules, and that they will trump whatever rules a mere state might put in place.
So Patrick, that's a great point. So the Securities and Exchange Commission in the U.S., or the SEC, has primacy of regulation within the 50 states over the 50 states. But what about Estonia or Singapore? Is the SEC going to give comity and recognize Estonian or Singaporean law to the extent you have an Estonian or Singaporean company that's doing business under a legal statute of its own country?
Well, it will give effect to Estonian law for internal matters, but those are not the most important matters. In terms of dealing with investors, the SEC takes the view that if the Estonian company is selling crypto assets in the United States or to US persons, then the US securities laws are implicated by that. And it's very hard to avoid that, because we're talking about purchases and sales that occur electronically, digitally, and electrons go everywhere. So you have to take extreme measures to avoid selling in the United States or to US persons if you want to avoid the US securities laws.
Well said, and we even hit the next slide. Tell me more about regulation by the Treasury Department.
Well, it's two things. There's the money service business regulation that you mentioned. There's also the need for compliance programs to make sure that money laundering is avoided. What do I mean by that? I mean, a very bad case, for example, would be a platform, or we'll call it an exchange or a platform, where crypto asset trading occurs, but is being used by narco terrorists to launder money. So the crypto exchanges, the platforms, all need to have know your customer policies and practices, so they can make sure they're dealing with only the right kind of people, I guess is the way I'd put it, and not with criminals.
Well said. So we go back to the securities laws. What are the statutes that are relevant in the United States, Patrick?
Sadly, they're all relevant, and we have 6 of them. We have a 1933 Act, a 1934 Act. This goes back forever. We have a 1939 Act, 2 statutes in 1940. Then we have the Sarbanes-Oxley Act in 2002 and Dodd-Frank in 2010. Those are the federal statutes that apply to securities regulation. It's a complicated field, and they cover these core concepts. What is a security? If it is a security, the laws cover them, and if it's not, they don't. Remember, if it's not, then it's probably a commodity or a derivative, and that's a good thing, because that's the CFTC, which is easier on you than the SEC.
So what's a security?
Well, stock, certainly, a promissory note, a bond, an investment contract.
What does the regime in the United States say if you are a security?
If it's a security and it's offered and sold to the public, then it needs to be registered with the SEC. And that's a laborious process that involves a lot of disclosure and a lot of written materials filed with the SEC and delivered to investors. And it requires the SEC to give its approval before you can proceed. The
And,
basic philosophy is tell the truth and you're okay. We won't stop you as long as you're telling the truth and the whole truth, but you have to put it in writing and you have to run it through the SEC.
Patrick, spoken like a maestro. What happens if you sell a security in violation of U.S. securities laws?
Well, if you violate this law, you have to be prepared to give the money back to anyone who bought from you for a year. If you do it and you don't tell the whole truth, you shade what you say, and you make misstatements of fact, or you omit important facts that should be stated. That's securities fraud, and you have to pay damages. You may get fined and punished in other ways for that as well. There's also the possibility of market manipulation, but let's not get into that for this program. That's rather technical. And
what is this issue that we call manipulation?
This is about trading in a market in a way that creates actual or apparent active trading in a security to raise or depress the price of that security in order to draw other people in. It's fake trading, basically.
We saw a lot of this with the ICOs, right?
It did happen. It did happen a lot, and it is said that other crypto assets are still manipulated. The reason we don't have an exchange-traded fund for Bitcoin in the United States today is that the SEC believes that the Bitcoin market is manipulated.
So Pat, I know we've got a limited amount of time. If I have a cryptocurrency, what are the analyses that I should run through to make sure that I'm following the laws in the United States? And you know, I have a lot of clients who want to comply, and then I have a lot of clients who want to make sure that they stay out of the United States so that they don't have to comply. And of course, I have to remind them that there are laws in other countries. And I'm glad that my friends at the Delight Group have put on this seminar so that we can all learn about them. But if we are going to be accessing a United States person, which means an American living abroad outside the U.S. that you intended to seek investment from, or seeking investment inside the United States from whoever it is that's here or using our mails or systems. What are the tests? And I see on this slide the first one is the Howey test. What's that?
That is a United States Supreme Court precedent that goes back, I think, 60 years to 1946. That had nothing to do with crypto assets. There were no crypto assets in 1946, but there were orange groves in Florida. And there was a developer who said, you know, I am going to offer a unique contract for sale. I'm going to offer for sale to folks in the north, in New York, New Jersey, California we'll leave alone. They have their own orange groves, but we will offer them a contract in which I promise to cultivate this orange grove, to maintain it, to harvest the oranges, to package them and sell them, and to manage it as a business. And it'll produce a profit, which I will then share with my investors. Northerners have been buying oranges from Florida for a long time. It's a special trade in the winter. So this was a welcome investment opportunity. The Securities and Exchange Commission, however, sued the developer. He said, you know, you're selling a security. The developer said, no, I'm not. I'm selling oranges. Oranges are not securities. The SEC disagreed. The case went all the way to the U.S. Supreme Court, which ruled that these contracts were in fact securities. I should say they were, as a matter of law, securities, because they were investment contracts. Why is that? Because they were an investment of money in a common enterprise. What's the common enterprise? Well, it's me, the investor, and you, the manager of the orange grove, with an expectation of profit, not consumption. You weren't giving me oranges, you were giving me money, which resulted from the profits created in the business. And I was relying on you, Orange Grove manager, for your managerial and entrepreneurial efforts to grow this business. Those are the elements of an investment contract. And so that was a security. And likewise, most crypto assets are treated as securities for the very same reasons today.
Well, thank you, because you've now answered my next question. Why do we care? And I think what you were trying to say is that if we avoid those 4 prongs of
Yes.
how we test at the bottom of this slide, maybe you're a utility token. And
That's
I think
right.
And I think
Right.
many thought that it came up with ingenious arguments as to why they satisfied each of the 4 prongs of the Howey test. But then they went out raising capital, seeking investment, and nonetheless triggered the securities laws, not because what they were selling necessarily was security. There was also some litigation, though,
Oh, yeah.
and I was involved with a number of investors in the Telegram transaction, so I'm not going to talk about it. I'll let you talk about this.
Well, so sometimes these token offerings get big. Telegram raised $1.7 billion, and was sued. And in New York federal court, where I was a law clerk, we both practiced there. It was ruled that the tons were securities. The court found as a fact that the 2 planned transactions, which had they been treated separately would have been okay, were in fact part of a single scheme, and that the single scheme and series of transactions was a security under the Howey test. In other words, the court integrated the 2 transactions, which destroyed the private placement exemption that could have been used for the first one. The result of this is that Telegram had to shut down. They paid a penalty of only, I put that in quotation marks, only $18.5 million. More importantly, they had to give back $1.2 billion to the investors.
Well, I have 2 questions. One is, what happened to the other 5.5 or 550 million? Number one, Pat, and then number 2 is, I think the Telegram messenger network still exists, doesn't it?
Yeah, I think it does, and I'm not sure it does. It certainly does still exist, but I don't think it operates via these tokens.
Correct. Correct.
And the reason the other 500 million could be kept, but don't take this as an invitation to do the same thing, is that they were sold outside the United States to non-US investors. And the SEC could only force disgorgement for US investors, which was 1.2 billion, but it was not 1.7 billion. So,
I think that's a convenient out. I think that Telegram had simply blown the money on development.
Well, there was that too. They'd blown a lot of the money and they couldn't give it back. And they had very good counsel, I will say. I mean, I think that helped a lot in dealing with the SEC, having very experienced counsel.
Tell me about Kik. How was Kik different, and where does Kik leave us?
Kik was sadly similar to Telegram. This came out in 2017 in the ICO, when ICOs were underway. Again, we had a putatively private pre-sale and followed by a public sale. And the pre-sale probably would have been a good private placement. It was conceded to be a security, the SAFT that was used, conceded to be a security, and it probably would have been a good private placement, a lawful one, except that the public sale followed 1 day later.
So it wasn't a public sale, right? It was a distribution event, what we call an airdrop, where the company attempted to create a network where there would have been utility by giving people free tokens, so that then the tokens would have a utility, and then the tokens sold previously in the good private pre-sale would have value. And so I think the SEC tried to destroy that attempt to that runaround of their regulation in that case.
Yeah, I think that's right.
How about Ripple?
Well, this is the latest, and this is the one that concerns a lot of us the most, because Ripple is very like Ether, if not like block, like Bitcoin. And remember the principle of being decentralized, sufficiently decentralized. If the token is sufficiently decentralized, then it's not a security, because the token holder is not relying upon the efforts of others. It's decentralized. So you can say that about Bitcoin, because again, Satoshi, we don't even know who he is, and he doesn't operate the Bitcoin network. He does not. Vitaly created Ether, but he does not operate Ethereum or produce Ether. That's decentralized. And Ripple said, well, we're like that. And unfortunately, plaintiffs in the class action said, no, somebody is behind Ripple. His name's Bradley Garlinghouse, and people around him. And they do continue to develop business for Ripple, and investors, token holders do rely on Garlinghouse and others. They're not like Satoshi. We can find him, and we know that he's doing this. Ripple disagrees. Ripple says, no, it's very decentralized. It's in the hands of a foundation. Don't try to tag us or Garlinghouse. But the class action plaintiffs disagree. There's a lot of money at stake here. And sadly, I'll say sadly, the SEC has brought suit too. And this is something that I view as, well, if not politically motivated, let's just say it's the last thing the SEC did before the SEC turned over, because the elections were held and a new commission was coming in. So what happened was the commissioners voted to bring this suit, knowing that they would soon be out of office and that another commission would have to prosecute the suit. Anyway, that lawsuit is pending, and it has to be taken into account by developers, because Ripple thought that it was not a security, and it may be exonerated in the end. Maybe exonerated, but has to fight the SEC.
We shall see. We're way over our allotted time, Pat. I'm so grateful for your tour de force on telling us all about the landscape here. I thought it would be really helpful if we could spend a few minutes to sum up. And I think the first point that you made so eloquently is that calling something a utility token doesn't get you out of the out of the headlights of the U.S. Securities and Exchange Commission. If it's sold like an investment, it will be regulated as such. And the attempts to bifurcate the sale and the utility have not worked. I think that more regulations are coming in the years ahead, as I think that sadly technology just radically overtook our ability to regulate and come up with case law, and just the way legislation is developed, it takes time for the political process to catch up. We've got 4 federal statutes, 51 state laws applying to the offering, trading, and investing, and we described the applicable regimes: commodities, derivatives, money, property. I thought that was really great. We talked about the fact that aside from the SEC in the states, that there's an active plaintiffs bar, and we didn't talk about the Department of Justice, which is the entity that typically cooperates with the SEC to bring criminal complaints. Of course, organizing your business outside of the U.S. to raise money inside isn't going to save you. Telegram showed us that. The Dow report showed us that. I think it's an area that is so complex that you really need a multidisciplinary team of experts, of which Patrick and I are only one of those areas. That's the securities area. You really need to have expert lawyers in the regulation of money. You need tax lawyers, and you need commodities and derivatives lawyers. And finally, we haven't talked about this, you need very smart contracts lawyers, because at the base, this is a smart contract, which is published on the blockchain. And with that, I'm going to say that we are wrapped, Patrick. Please share with us any final words of advice.
No, I agree. If someone tells you that he or she is a crypto expert, you should run, not walk in the opposite direction. This field is too complex for any one person to be expert in all of it. I only purport to understand part of it. Fortunately, I have partners like Louis, who can help me with the parts that I don't understand because my bandwidth is only so wide. So when you get help in this field, make sure you get help in all of these subspecialties, because there are too many laws that apply and too many ways to go wrong without that specialized help.
Thank you, Patrick. And signing off from San Francisco and Silicon Valley, I'm Louis Lehot, and we're lawyers at the international law firm of Foley and Lardner. And I was delighted to be invited by the Delight Law Group from Seoul to join you today. If you have any questions, don't hesitate to reach out to me at lehot@foley.com or pdaughterty@foley.com. A copy of these slides will be made available. And a big hello to my friend Chan Woo Sung, and thank you very much for joining us today.
All best wishes.